case briefs, and so much more. LSData's got what you're looking for.
In 1991, the Supreme Court of the United States heard the case of Board of Governors of the Federal Reserve System v. MCorp Financial Inc. The case revolved around whether administrative proceedings were protected by bankruptcy law, ultimately determining that they were not generally protected by the automatic stay provisions of the Bankruptcy Code. The lawsuit centered on MCorp, a bank holding company accused in 1984 of violating a regulation that required companies to support their subsidiary banks financially and managerially. In response, the Board of Governors issued cease-and-desist orders, and the FDIC was appointed as the receiver for 20 of MCorp's subsidiary banks after their creditors filed for bankruptcy. MCorp itself also filed for bankruptcy. However, the board initiated a separate administrative proceeding, alleging a violation of the Federal Reserve Act and accusing MCorp of unsafe and unsound banking practices. MCorp argued that the proceedings should be subject to the automatic stay provisions of the Bankruptcy Code, but the court rejected this argument. The court held that ongoing administrative proceedings were not subject to the Bankruptcy Code's automatic stay provisions, and that MCorp had an unquestioned right to review the regulation and its application in the Court of Appeals if the board found them to be in violation. Ultimately, the Court of Appeals' prior decisions were partially reversed and affirmed, with the court determining that administrative proceedings could proceed despite the automatic stay protections present in bankruptcy law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.